turn to the next case on this morning's docket. That is case number 103155, John Boucek, Richard Boucek, and Diana Peck as executors of the estate of Bernice E. Boucek, deceased.
Ready, Your Honor? Your Honor, may it please the Court, my name is David R. Clausen, and may I have the permission to reserve 5 minutes of rebuttal time?
5 minutes is granted.
Thank you, Your Honor. In this case, as I'm talking about it with you, I'm going to refer to the parties by their first names because everybody in this case is a Boucek by blood or name, and if I tried to use any other way to describe them, either you would get confused or I would get confused. This case is up on appeal of a summary judgment ruling by the court at the district court level. John was not the movant, so the standard that applies, which is the summary judgment standard, is that the court must resolve all facts and inferences which may reasonably be drawn from the evidence in favor of John. What's involved in this case are two of the strongest estate planning instruments known to the law. One is a joint mutual and contractual will, and the other is an irrevocable trust, and they're in the same case. Both of these documents are unambiguous. Nobody talks about them as being ambiguous at all. I'm not going to go through all of what I had in the brief, but I do want to highlight a few points in this matter. First off, Bernice and Clarence, the parents, clearly intended the 1989 will to be controlled by the laws relating to joint, mutual, and contractual wills. You'll see why I say that as we go along, but the corollary to that is Clarence and Bernice clearly intended the 1996 trust to be controlled by the laws relating to irrevocable trusts. Throughout this situation, it seems like some people are confusing, or sometimes the defendants are trying to confuse what the claims are being made, but they are clearly set forth. The first claim, John is making three claims. The first is breach of the 1989 will. And of course, what were those breaches? The probate of a 2004 will created by Bernice after Clarence had died, and transfers by Bernice of her property to a 2004 will that disinherited John.
A trust, you mean, 2004
I'm sorry,
trust.
I will have that problem along the way. Help me on that. Yes, that's right, 2004 trust for no consideration that disinherited John.
And that was a revocable inter vivos living trust.
The 2004 trust was revocable.
Right.
All right. Then the second claim is a breach of the 1996 trust. And the breach, of course, is related to the transfers of property from the 1996 trust by Bernice as the trustee of that irrevocable trust to the 2004 trust that was revocable and in her name.
Counsel, let me just clarify a couple facts here. So the breach of contract claim is totally based on the 1989 will in terms of the property that would have passed under that will. And the breach of trust claim is based on the 96 trust, correct?
Right. But
so
of course
in that way, you cover the entire estate.
Right.
Part of it under the 1989 will and part of it under the 96 trust.
Yes.
Okay.
Okay.
I have a question on the trust, but I want you to go ahead and state your third claim, so then we can go back and talk about them.
The third claim is constructive fraud, and it's based on the breach of the 1989 will and on the breach of the 1996 trust. Now, the Court of Appeals had a little problem with that. They didn't think there was a confidential relationship with regard to a will, but they cite a will that's just an ordinary will, so to speak, not a joint mutual and contractual will, and that beneficiaries don't gain a confidential relationship there. But Draper and Judd both show us that you do in the case like this.
May I follow up just for a moment? So that third claim is really belts and suspenders. It rises and falls with the first two claims.
Well, it could rise.
You could only get the same constructive trust imposed which is what you're seeking, I understand you to be seeking, based on the third claim wouldn't give you anything more than what you would get if you succeeded on the first two claims.
Well, it would, because if we find a breach on the first claim, that doesn't give us anything back. They've transferred a bunch of this property out. We've got to go get it. And if we ended up winning on the first claim but not the second claim, the constructive fraud would still apply.
What I'm suggesting is that the first two claims together, are what you could get as a result is coextensive with what you get on the third claim.
Right, because it's based on the breach so that we get the right to go get it back, yes.
Right. Okay, thank you.
Okay.
I had a couple of factual questions dealing with the 96 trust. Does it still exist?
If you say, does it still exist, with the claims going on here, Bernice transferred everything out of the 1996 trust.
So if it does exist, it's illusory because there's no property upon which the trust will operate as of now.
No, if it exists, it's because I won in this case and that property has to come back. It shouldn't have gone. So that's why I'm a little hesitant to say it doesn't exist.
Okay. There is no property in the 96 trust as of right now.
Not that I know of.
Okay. Did the 96 trust, did all of the property get transferred to the 96 trust?
Are you asking, did all of the property that Bernice and Clarence have ever get transferred there? The answer is no. And that's clear from when you see the transfers to the 2004 trust. The bulk of those transfers come from Bernice individually.
Including the farmland.
Well, there's quite a bit of farmland there, so I don't know what you're talking
the
about.
home place, the property that's described in both the will and the trust.
I call it the reference tract.
Okay.
And the reference tract actually got deeded by her individually
To the 2004.
to the 2004 trust,
Okay.
and that's the big deal. That's conflicting with what everybody else is saying that it's in the trust. It's very surprising. I'll be talking about that.
You done?
Yeah.
That leads me to the next 96 trust question. That property that did get placed in the trust, what did it go to Bernice and then to her 04 trust, or was there a direct transfer from the 96 to the 04? I'm trying to determine the property coming out of the 96. Was it a distribution to the trustee / settlor, or was it a distribution to another trustee?
The two tracts, I don't know how to describe them, so I'll just put in how I understand it. There's two tracts that were put in there that were undivided half interests in property that Bernice inherited from her family. She signed the deed putting him in while Clarence was alive, and he never signed that deed, so he may not have known that it happened. But that property was there, and she deeded it as the trustee of the 1996 trust directly out of the trust into the 2004 trust.
Okay, so there was some property that went directly from the 96 to the 2004, and I'm assuming you're alleging that those transfers were without consideration.
They were without consideration. All right. If I want to answer that question a little more fully, there's another tract that seemed to be in there, an undivided 1/2 interest, and while the defendants make a big deal out of it, when you look at it, it's probably a tract of about a little more than 5 acres, and they own an undivided half interest, so that's just a little more than 2 acres. And somehow in exchanges that we're going to be talking about where they bought land together, it may have come out of that trust to Bernice individually when that transacted, but then she deeded it from herself to that 2004 trust again. All right, back to where I was. Testamentary law must inform any analysis of the 1989 will as a contract. Now, the reason I'm saying that is every time we talked about something that arose under testamentary law, the Court of Appeals would say, but isn't the will revoked because of the 2004 will? Why are we talking about testamentary? Well, just like when you do a contract on oil and gas and you look at the lease, the oil and gas law informs you how you look at the contract. So too, when you have a contract that is both a contract testamentary in character and a will contractual in character, testamentary law does inform it. I'll give you a couple examples. The first one is under KSA 5916, which we raised. They never, when they wanted to revoke the 1989 will as a will or a contract, ever bothered to do another will or to make another thing that's involved in there, which is make a very specific declaration they're revoking it.
What? Now, give me that statute again.
59-611.
Okay.
When we talked about the will, that requires how you revoke it, but it also affects the contract because if you don't have a specific declaration in that trust that you're revoking this contract or will, how could you have done it? Okay? Then the other thing is, it definitely shows that you can't find a meeting of the mind or mutual assent if we don't have somebody saying that's what we intend to do. The other one that's very interesting to me, and it's really strong in this case, I just have a hard time believing I'm fighting so hard in this case with regard to it. That's 59-618A. Okay, now that's testamentary.
Is the affidavit in the record on appeal?
Yes.
And Bernice signed that affidavit?
She did.
And she swore that she was putting this a will of record in order to preserve it for future use?
Just like the form affidavit says, yes, Your Honor.
But it didn't get filed within the requisite 6 months.
That's not true.
Okay.
Okay, that's what the defendants are alleging. But you understand that the statute that gives you that if it turns out the last day of your period falls on a weekend when the court's not open, and in this particular case, that period fell on a Sunday. And that being the case, that under Chapter 60, the cases say that applies to anything, including the probate code. They filed it on Monday. That was the first time they could have done it, and if they didn't have until Monday, they wouldn't have had the requisite amount of time to get it filed.
But do I understand that she only filed a copy?
She did only file a copy, but don't get distracted by that, because nobody is out there trying to probate that 1989 will. We're not even doing that. But this is, again, being informed in testamentary law when you look at the contract. Bernice went and did that. She testified, oh, we thought the 1996 trust revoked the 1989 will. Really? Look what she did shortly after the date of Clarence's death. She files this will, which is a will and a contract. What's she saying? It's still effective. She's also saying that it shows her intent that Bernice intended, and she believed Clarence intended at the time of his death, that 1996 will did not revoke the 1989 will. Clarence participated a little bit that before his death, because how did that copy of that will get down to Mr. Balefield's office, which is the attorney? The testimony is from Bernice. Clarence did it. Okay? So Clarence is also showing he didn't see that will as being revoked by the trust. And this is very strong evidence, because what do we have? Like you were saying, Your Honor.
Could I have that again? Clarence took the 89 will to an estate planning attorney after the execution of the 96 irrevocable trust.
There is evidence in here that's being denied by the defendants, but I don't know how they can do it, and this is it. John testified that shortly before his father's death, he had a conversation with him. And in that conversation, Clarence said, we didn't use a trust, there's nothing in it. The will is what I want to stand by and I want it to hold. We need to do something, okay? Now, they come back and bring up evidence saying, he couldn't have done that. And I mean, everybody's guessing when he went to the hospital, because everybody that testified, they went anywhere from 2 weeks to 4 weeks or maybe a little more. And really the denial of John's testimony that he talked to his dad and he said that is more as to the time of when it occurred, not that it did occur, because nobody else was there but John and Clarence.
So one of two things had to happen. After the 96 trust was executed, but not all the property was transferred to the trust, then the property that did not get into the trust in that period between 96 and 98 was either governed by the 89 will, or if the trust had revoked the 89 will, then it was subject to intestate succession.
Okay, I'm going to respond to that. No, there's no way in what we're arguing that there's any intestate succession here. Okay?
But if the 96, what I'm saying is, if the 96 trust did indeed revoke the 89 will, but they didn't transfer all the property into the trust wouldn't operate on property that's not transferred to it. And so what is operating on that property that did not get transferred?
Okay, let me understand the question. You're saying hypothetically.
Right.
Because if hypothetically that 1996 trust revoked the 89 will, then that's right. then there's a bunch of property never got into the trust, and it would be.
Then it was subject to none of the documents that Clarence and Bernice had executed.
But it gets worse even than that. Without even the trust revoking the 1989 will, at the appeals court level, the appellate court argues if it ever went into the trust, and then for some reason they say, let's take it back out again, and so they bring it out to themselves. They say it's not, again, subject to the 1989 will. How's that possible? The 1989 will, under statute and under case law, covers after acquired property. And the other thing that you have to realize, too, you look at those two documents, they're complementary. They are not antagonistic. Yes, it's a little different form to go through, but when you look at the bundle of rights, everybody's getting the same total property in the tail end that they got under both documents.
Does the record reflect, I read that part of the reason to do the irrevocable trust, which is unusual, was because of Clarence's illness and a fear of catastrophic medical bills?
That's correct. In fact, it seemed to be kind of a principal one. And yet,
is there any argument if the purpose was to place it in an irrevocable trust to get it away from medical care creditors, and then Bernice takes it back out, that was a fraud committed on creditors?
we point that out, but remember from the days of practice of law that you do it, and if nobody attacks you, guess what happened?
Right.
It wasn't a fraudulent conveyance because you have to have somebody hurt on that.
Right.
And that's kind of what happened on this situation. However, it's interesting to note that.
So you're saying there were no creditors that were beat out of their money because of the transfers?
Right. He died a little quicker than people thought. They had a little bit more insurance coverage than they thought because of a job she had, so they got away with it. But that's why it was created. But also when you look at it, they're creating it to protect those transfers under the will because that's where the property's going. Even Bernice at one time said it wasn't the disposition, and everybody's testifying it was the creditors they were worried about. Okay?
Counsel?
Record question, counsel?
Sure, go ahead.
This will just take a second. I'm finding pretrial questionnaires and amended pretrial questionnaires in the record, but no pretrial order. Did you never reach that stage?
I am not, right off the top of my head right now, I can't remember on the pretrial order. I think
Okay.
if there was one.
The petition, the original petition, and the amended pretrial questionnaire from your side of the case indicates there was a confidential relationship between Bernice and John. It doesn't
Yep.
talk about a confidential relationship between Bernice and Clarence.
Okay, but there is, and we know under Draper and Judd, under Draper, the confidential relationship is between the husband and the wife. So that's there. But under Judd, the confidential relationship that's talked about is between the testator and beneficiaries.
Okay.
Well, you also have a fiduciary relationship between the trustee of the 96 trust and the beneficiaries, don't you?
Very true. But we were just talking about the will for the moment, is my
Right,
understanding.
right.
Yeah. No, that's very true. And a duty of, good faith and fair dealings in both.
Counsel, I see you're out of time. Would you
I
like
see that.
about 30 seconds to wrap up?
Okay, I have reserved 5 minutes, so I may
That's
come
true.
back with some of that there, so let's just do it that way.
Okay, before you sit, do we have any further questions of counsel? Thank you, counsel.
Thank you, Your Honor.
May it please the court, I'm Bob Martin, and I'm here today on behalf of the appellees and actually cross petitioners. And just to address some of the things that have just been talked about before I go on my long-winded spiel, which I hope will be short-winded, there were deeds besides the deeds transferring the certain real estate in to the 96 Trust. There were subsequent deeds out to even John Boucek, to the petitioner appellant, and transferring property around that he was aware of, that he even signed on transferring property around in dealing with that in the early 2000s.
So there were deeds transferring property out of the 96 trust that were transferred without consideration?
Yes.
And what authority, and Bernice did those?
Yes.
By what authority did she transfer out of the trust without consideration?
Under the, and So she signed the deeds. The answer to it is one, yes, she signed the deeds as trustee, but two, under authority of the trust, and that's the language that the Court of Appeals relied upon in their decision.
The Court of Appeals relied on language that provided a broad authority for the trustee to handle the trust affairs. If you tell a CEO of a corporation you have broad authority, you run the company like you want, that doesn't mean that the CEO can take the corporate jet as his own property. You have to deal with the property in connection with the trust. So I see you can't use the authority, management authority, does not trump distribution provisions in the trust. Is there any provision in the trust where Bernice could transfer this property in the way that she did?
And we're talking about the irrevocable trust, there was language provided in it, and there is language in the trust providing the ability to make transfer. There's broad language, not just transfer. It's in a different location in the trust as far as the ability to make transfers. Does it use the word gift? I don't recall it uses the word gift, if that's what you're asking me more specifically.
She effectively did a de facto termination of the trust.
She did.
And if you look up irrevocable trust in Black's Law Dictionary, it defines it as, quote, a trust that cannot be terminated by the settlor once it is created, end quote. Bernice was a settlor of this irrevocable trust.
She was one of the settlers of the irrevocable trust.
And she effectively revoked that trust by transferring all of the property out without any consideration.
I believe that there was some consideration on certain of the transfers as it involved the switching of land, but I want to be clear.
But none on others.
But none on others.
And there's nothing left in the trust. There's no property in the trust today.
There was no property left in the trust today.
And so how can she effectively revoke that trust?
She transferred out. There was certain property that was not in the trust. There was certain property in the trust. She transferred that property out with full knowledge of at least constructive, if not actual, because Mr. John Boucek was involved in certain of those transfers. He knew what was going on. The part that is really strange to me, the part that is extremely odd to me in this case, in even discussing this, is that John Boucek is coming forward and saying, I'm claiming under that 96 trust. He stated in his deposition, he stated trial in the probate case, I'm claiming under the 89 will. I'm not claiming under the 96 trust. His attorney files paperwork saying he's claiming that way, but that's not his testimony. That's not what he says. I don't think they ever used it, that they ever intended to use it.
Don't intend to use the 96 trust. What's the breach of trust about then? They have a claim from the very beginning on breach of trust.
That's why I don't understand. I don't understand how you say you don't have a claim for it, that you knew about it back in 2000, making these transfers without consideration.
I think the transfers that are being attacked are the transfers that were effected in 2004.
Those are the ones that were made into the new trust, but there were other transfers back then that moved the property.
But they're not suing on those, are they?
Yes,
they're suing on what happened in 2004.
They want certain of the property that was transferred in 2000 brought back into because that's their catch-all. That's they're discussing the 89 trust, the 89 will, the catch-all. They're wanting certain of the property that was transferred back then. They want everything brought back in. And this isn't in a vacuum as far as what's going on. There were lawsuits, at least 4 other lawsuits before this 06 case, and after they say Clarence's name, he went by Frank. After Frank died, the father died between the mother and being sued by John Boucek, among others. So that he sued. So this is not in a vacuum. There's a lot going on here. There are other lawsuits that they don't bring up claims in. They get settled, they get dismissed, they get reserved. There's a bankruptcy that's involved where he doesn't assert that he owns a contractual interest in the property. But there's statute of limitations problems with them saying, hey, I'm objecting now to these transfers, but I didn't, or at least latches. I didn't object then. I'm not going to do anything about it then, but I'm going to wait now. I'm going to play gotcha. The home place, I'd rather refer to it as the home place in the reference track, was treated differently. there was a clear difference between a fee simple discussion of how it gets transferred in the 89 will and the life estate that is discussed.
But it never actually got transferred into the trust, did it?
It was never deeded. That is correct. Whether or not it was transferred under
So whether it was
Pharaoh.
recited or not,
What?
what's the significance of it being recited? You're just saying that's an inconsistency that points to an implied revocation of the 89 will?
Implied revocation, but I believe under Pharaoh, since that real estate listed on the Schedule A was found to be in that trust. I believe that.
There is no Schedule A. No one's ever located Schedule A.
I agree. Which is better, to have it on Schedule A, to write it into the trust itself? I would take the position it's better to write it into the very trust itself than attach Schedule A. At least it's involved.
So the absence of the deed makes no difference?
For that, I think the absence of the deed under Pharaoh makes no difference because it was written specific. Which is better? Have it on a Schedule A that's slapped on later, or write it, your home place, into the document itself? Yes, Justice.
So you're saying that you can transfer real estate to a trust by simply saying in the trust document that the trust is to operate on that real estate?
I believe that's a holding in Pharaoh. Because there were no deeds in Pharaoh, solely the Schedule A. On the 89 will, never been found. It was last known to be, as testified by John Boucek, in the possession of Frank, the father. They're saying was never obliterated under 59-611. Well, if you can't find it, it's probably pretty well obliterated. There's a presumption that if it's not found.
But we're not dealing with the will. We're not the will as a testamentary document. That train left the station. We've already had a holding that you probate the 04 will, even if it's in breach of contract. That's a holding.
Yes.
So we're not looking at the 89 will as a testamentary document.
Okay.
We're looking at it as a contract, a statement of the contract between Bernice and Frank.
Correct.
And Bernice filed that copy of that contract with the court under 59-618A, specifically with an affidavit where she swore that she was filing this to preserve it for future use. And she did that 2 years after Frank died.
I thought we weren't, Justice. It was done 6 months, just over 6 months after Frank died is when it was filed.
Right.
If we're not talking about the will as a probate item, why do we care about it being filed in the probate code under 59-618?
Because it's a statement that the contract is still valid.
Okay. And the facts surrounding it are that was not who drafted, the affidavit was drafted and filed by an attorney who was not the one who drafted the will, the 89 will, was not the one who drafted the 96 trust. It was a different attorney, one that John Boucek had been in contact with, that she was not happy after.
But those are just facts.
Yes.
Those are just facts that tend to contradict, as your opponent pointed out when he was speaking to us, there's some contradiction between the action that was taken after Frank's death, the filing of that will to make a record with the affidavit, versus her current testimony or the testimony that's been preserved now, that she didn't really know what she was doing, etc. Those are facts. And when you've got facts that contradict, summary judgment's inappropriate, isn't it?
The facts, as they involve what was done, I don't think those facts, as far as what was done with that will, are even relevant. I don't think they're relevant facts. Because I think clearly when the 96 will was done, or 96 trust was done, that the will went out. So once it's been revoked as a contractual item, it's not restated. I mean, as far as if you want to talk about the trust was filed with the Registry of Deeds office as well during that same time period. And it's the trust that's in the record is filed stamped with the Registry of Deeds office. But I think that once it was revoked, that will is gone. And if there's any ambiguity, the scrivener took care of it. He said that clearly, and Bernice the same way, the trust was to replace the will. There was no doubt in his mind. Because the will was done quickly because he was going on a trip, that both of them were going on a trip. His sister was dying.
But it didn't.
What?
The trust didn't replace the will. Because if the trust was to replace the will, all of the property would have been made subject to the will, but all the property was not made subject to the will. There was property that did not make it into the 96 trust, correct?
That is correct.
And so, how can you say it replaced the will? That would have left then the property that did not get subject to the transferred and subject to the trust would not be subject to anything except the laws of intestacy.
By revocation, by revoking the earlier document, correct.
And you're saying it was the intent of Frank and Bernice to put part of their property in a trust, revoke their 89 will, and then leave some property subject to intestate succession.
No, that's not what I'm saying. I'm saying that they had the full intention to revoke it with the subsequent later document.
Why wasn't it an incomplete revocation then if they intended to put all the property in there as a revocation and they didn't get it done? Why isn't that an incomplete revocation?
I don't know what an incomplete revocation is.
Why doesn't it leave us with a question of fact as to whether that really was their intent, since they didn't act and complete all of the transfers that were necessary?
What additional facts could be obtained other than for the trier of fact? He's dead, she's dead, the documents are what
Somebody
they are.
has to weigh. A trier of fact usually is who would weigh.
Right.
Your statement that there was a clear intent by creating the trust versus the argument that there was not a clear intent because they didn't act on it and transfer the property.
If you read the trust,
you have to take that, and don't you agree that that potentially presents a question of fact?
I think that it is clearer as it involves the fact that the trust, by its own language, is inconsistent with the will and is the subsequent document. So if it revokes it, the earlier document, much like I've cited a prenup and a will were involved in another case, then if that's the case and revocation occurs for the earlier document, the rest of the facts are not material. It's if it is revoked by the four corners of the documents, the two documents comparing one to the other, then the surrounding facts don't matter.
So it's revocation by implication, and the implication is because of what the 96 trust says.
Correct.
What it doesn't say is that it revokes the 89 will. I mean, it doesn't say that.
It does not say that.
And I look at that, and I look at the testimony that the purpose of the 96 trust was to shelter these assets against catastrophic medical bills. Do you agree that that was the testimony as to why they created the 96 trust?
The testimony was to keep the family farm together that would be lost due to excessive medical bills.
Okay, and so when I look at that purpose and I look at that 96 trust, except for the fact that they've utilized the life estate with the home place, the homestead, it basically effectuates inter vivos what the will would have only done after death.
It is very similar.
Well, it is very similar, and so I see it as a instrument, because the will is not effective until death. You'll agree with that legally.
Yes.
And so when
As a will.
Frank, as a will. We've got the contract, but as a will, it's not effective. But if they do the irrevocable inter vivos will, that immediately puts into effect what they wanted to do without waiting for the will to kick in at death, correct?
Correct.
And so I see it more as a immediate implementation of the 89 will rather than a revocation of what we said we wanted to do. Do you understand what I'm saying? You could read this 96 trust as a corroborating what we said in 89, with the only minor changes being life estates that an outright transfer.
Which is a pretty significant change, though. I mean, they didn't mimic everything into the same document.
Counsel, let me ask you a couple questions about the 96 trust document and what kind of powers, authority, duties it gave to Bernice. Did she have a fiduciary duty to the trust itself under that document, in your view?
In general, she would have a fiduciary duty as trustee.
Well, it also has language in at least two places, doesn't it, that she's to do whatever she does, including the handling that the Court of Appeals relied upon, in the best interest of the trust.
That is true.
Thank you.
And how can you characterize the transfer of property out of the trust without consideration as being an act that's in the best interest of the trust?
She was the key beneficiary of the trust during her life. She was the beneficiary.
Original beneficiary.
What?
She's the original beneficiary.
Beneficiary, correct. During her life. So the transfer was for her benefit.
But that isn't what we're asking. We're asking for the best interest of the trust, and the trust is an entity apart, separate and apart from Bernice.
Correct.
Even though she may have been the initial principal beneficiary and the settlor and the trustee, nevertheless, there were other interests involved in the trust besides Bernice. And as a fiduciary for the trust, she had an obligation to look out for everyone's interest, didn't she?
She had a fiduciary duty that she owed to beneficiaries of the trust.
And that would include John.
That would include John. Of course, if he thought that it was being breached, he could have done something back in 2000 instead of being a part of it, or prior to that time when they were running farm income through and expenses and avoiding the use of the trust. I mean, he wants to come now and say, well, I don't want to use, or his attorneys want to come and say, he's not even saying it, I want to use this trust to try to, as a safety net for me, even though I didn't do anything about it. As a there are some and just some side issues that the Court of Appeals touched on, and I understand that the district court based its decision on what the probate decision, which was limited by the Court of Appeals, and then this court refused to accept petition on. The Court of Appeals, though, in their decision, discussed certain of the statute of limitations arguments, which I've touched on as they involve the trust and the farming operation in my brief, and it matters that suit was not filed for any violation then, knowing that if they thought something really bad was going on. In fact, suit was not filed in this case until September of 2006. The deeds were signed in August of 2004. But the further part of the Court of Appeals decision had to do with whether or not, it limited the scope, I guess, to send back on what was in the trust and what was not in the trust. My reading of the Court of Appeals decision, the first half, is that the trust superseded the will. When you get to the questions they ask for evidence on, I'm not sure that's exactly what they're saying in their latter part of their decision. When you get to the end of it, because those questions would not matter if the 89 will was replaced by the 96 trust. And do you see that? And we have cross-petitioned based upon those additional facts and additional defenses, but those were, that's the one issue in that decision, or one of the issues in the decision we've raised as far as in our cross-petition. Any further questions?
Does that conclude your presentation, counsel?
It does.
Any further questions of counsel? Thank you.
Thank you.
You reserve 5 minutes for rebuttal.
Your Honor, quickly then, may it please the court. First off, I want to say that no matter when his deeds were drawn up, John was not party to that. He was not even informed of that. They were not filed until September 8th of 2004. That's the first John could have known of it. And the filing on September 6th of 2006 is within the 2-year statute. It's within the 5-year statute. The other thing is John wasn't a trustee.
Okay, now, let me make sure I understand your argument. You're saying regardless of when they were executed, that they were filed, that you filed suit within 2 years of the recording of the deeds.
Yes, because that's the first we could even know that it happened. They
I
were
just needed to know what your
Okay.
argument was, yeah.
All right. Then the other is, he talks about some transfers that happened back in 1999 and 2000. Okay? Those are not part of what we're being suing for unless they're part that she owned on the date of her death. Now, the thing that was going on during that time, they throw a bunch of deeds out in front of you. And he starts naming the deeds track 3 if they come out of the northeast quarter, but there's a whole bunch of different descriptions come out of the northeast quarter of 28. There's testimony, though, from not only John, but from Bernice, his own client. What were all these deeds? We went through them, and what she said and what he said is there's no hanky-panky going on. John, Richard, and Bernice occasionally bought tracts of land together. They'd each pay for some part of it, and then they had to split up the land. Okay? That's what was going on with those deeds, and yet he wants to use them as a triggering point for many of his affirmative defenses. And a lot of those deeds have, number 3 is the exception from the valuation questionnaire. They had trouble getting the description right, the correction deeds. Okay? So the situation that I'm getting at is all those deeds are not hanky-panky and underhanded things going on, and his own client testified to that. They were dividing up property they held and bought together so that each got what they'd paid for. The next thing I wanted to come to quickly was the reference tract. I call it the reference tract. That's the piece that's in the trust because it's in the body of the trust. I want to point out quickly to the court that in Pizzle, guess what? That trust has the land described in the body of the trust. Of course, now it's got a failed deed because the attorney hang on to the deed. But if just saying it in the body of trust would give an alternative argument like Terry Fellow, then why not? They could have had that secondary argument right there in Pizzell because that property is named in the trust. It's in the body. But you look at the wording on this trust, the 96 trust, and you see they're intending there to be a transfer assignment. It's not a declaration. Telly Farrow, it's clear, and the evidence is in there. He declares, I'm not doing any more, and this stuff I'm holding is in trust. That's not what the 96 trust is about. And there's no testimony to that. In fact, it's more like the Pizzell case because they thought maybe the trust, if they named it in Exhibit A, they might file it, and then it would be a transfer. They never had Exhibit A, so there's nothing into that transfer. Then they file the trust, and guess where it goes? Does it go on the real estate record? No, it doesn't. It goes into the miscellaneous filings, and you see that off the front of it. You're not going to see that trust unless you know it's there because it isn't on any real estate. Okay. Next thing I want to talk about is judicial estoppel quickly, bankruptcy. Okay. First of all, with regard to the 1989 will, the cases say that the state law defines what property rights are. We look at the Burnham decision, and what do we come out with? They didn't probate the 1989 will when Clarence died. So what has John got in it? Nothing. No rights vest in him. The property goes completely to Bernice. Fee simple, absolute, everything. He has nothing. All right. He files bankruptcy, and there's nothing there. Now, there is one case. It's a little old, but it's right on it. And that's Lage, L-A-G-E. And that was a case just like that, a little bit different. They did probate their will in another state, but ours was not probated. And so, and she wasn't dead. Don't forget, she didn't die till 7 years later. Now, there is a provision under the bankruptcy code that says under 11-541-5A, somebody dies and you inherit something under that will and it happens within 180 days of filing, then it's in. Well, that didn't happen. And she didn't have anything. He didn't have anything of an interest in property of that estate from his father's death, Clarence, in 1998. So nothing under the 1989 will would have gone in. The trust's a little different. John came with the idea that there wasn't anything in the trust hadn't been used because of a conversation that he had with Clarence. Now, I understand that Clarence died just before he died. I understand why Clarence may not have known everything about it. That's because Bernice transferred some property in there and never told him about it. But in any event, if that was wrong, then there probably should have been a trust disclosed in there. But then again, it was not by actual intent to defraud or hide or anything that it didn't get there. We just didn't know it. Okay? And the estate can be reopened if it has to, but the law out there says don't apply that judicial, the judicial estoppel is not to be applied as a technical defense. It's an extraordinary remedy And many times to protect the integrity of the courts, you end up actually having that backfire on you when in a bankruptcy case, you cut off that claim, and now you've hurt the debtor, you've hurt the creditors, and the party who you cut it off for is typically the third party that's been making the trouble that got it all there. And the debts that he went to bankruptcy with were debts he assumed from his father Clarence before they ran him off. Your Honor, I would ask that you rule in accordance with the petition that we filed and that also in the briefs that we've shown. But I thank you.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. At this time, the court will stand in recess for 15 minutes.